All right, hello everyone. Welcome. I'm Leonard French, your favorite copyright attorney, still coming at you from this sort of makeshift studio here. Well, I guess it's not makeshift, it's just under construction. Anyway, joining you I think it's still Monday in the US at about 5 o'clock, and I just got word that there is a ruling in the Stebbins v. Polano case. Remember, this was the accidental live stream case. We'll go over all the details in the actual ruling because the judge already breaks that all out. But this was the accidental live stream case that has been winding its way through the Northern District of California court system for the past year, has reached 158 docket entries. This decision is the 158th docket entry, and has annoyed a rather large number of people because nobody really thinks that this is the way you should try to enforce such of paywalled copyright content kind of thing. But I'll let you form your own opinions as to the rest of that. Let's take a look at the document. You might remember that David Stebbins' Acerthorn had opposed when Alphabet tried to intervene. He dismissed them from the case when he thought that they were going to win, and then they came back. And then when the judge wasn't ruling on his opposition fast enough, he went to the Ninth Circuit Court of Appeals and asked them to force the judge to rule. Well, now the judge has ruled, so Mr. Stebbins is getting pretty much exactly what he asked for. Maybe not what he wanted, but what he has asked for. So let's take a look, without further ado, at the decision, the order granting the motion to intervene, the former defendant's motion to intervene, the order denying the motion for a default judgment, and an order dismissing the action. Now before the court for consideration is all that stuff. The intervention was filed by Alphabet and YouTube. I've been calling them Google, the Google parties, because I grew up with them as Google. For the reasons below, the court grants the motion to intervene, denies the motion for default judgment, and dismisses the complaint with prejudice. With prejudice means the case and its claims are completely extinguished, cannot be filed again. This is the same thing as getting a judgment against you. Plaintiff David Stebbins asserts copyright infringement claims against defendants Raul Mateus, Carl Polano, and Frederick Allison, collectively the individual defendants. All three individual defendants have defaulted. Plaintiff also initially sued Alphabet, Amazon, and Discord, seeking an injunction that would require those entities, the corporate defendants, to ban the individual defendants from their services. Plaintiff alleges that individual defendants posted copies of an accidental livestream video on YouTube, Twitch, and Discord. The livestream video at issue was created on April 10th, 2021, when plaintiff's livestream software turned on of its own accord, unbeknownst to him. The, quote, only interesting and memorable thing that occurred during the nearly 2-hour boring and contentless livestream were strange noises that plaintiff did not cause. Plaintiff registered the live stream with the United States Copyright Office. While plaintiff pursued his claims in this action, he also filed a similar case, Stebbins v. Rabolo, which alleges additional claims of infringement of the same content. Plaintiff seeks injunctive relief against the corporate defendants in the related case. That case is stayed, pending final resolution of this matter. On April 7, 2022, plaintiff filed a motion for default judgment against the individual defendants, which then repeats on April 7th, 2022. Plaintiff voluntarily dismissed the corporate defendants to prevent them from moving to dismiss his claim, and in the hope of obtaining a default judgment against the individual defendants. The corporate defendants moved to intervene to oppose plaintiff's motion for default judgment on the basis that they remain defendants in the related action, which also addresses the copyrightability of the livestream. Plaintiff opposes the motion to intervene. And the court has some footnotes here. One, the court takes judicial notice of plaintiff's application to register the accidental live stream with the United States Copyright Office because it is a matter of public record and is not subject to dispute. Plaintiff has been deemed a vexatious litigant in the past, and numerous courts and districts across the country have dismissed his lawsuits as frivolous and meritless, and the court lists those. frivolous, clearly baseless, undisputed that Stebbins has proceeded IFP on at least 16 complaints that proved meritless, has filed numerous frivolous motions, etc., etc. And then a third footnote, plaintiff disregarded the court's order denying his request to file a supplemental brief in response to the motion to intervene and submitted a second request to file a supplemental brief. The court denies the request to file a supplemental brief and strikes the unauthorized filings at docket numbers 153 and 154. Okay, so where do we leave off here? Alphabet and YouTube seek leave to intervene under Federal Rule of Civil Procedure 24B. We've gone over this a little bit. It requires an independent ground for jurisdiction, a timely motion, and a common question of law and fact between the movant's claim or defense and the main action. So the intervention needs to be related, or a common question of law and fact. Unlike intervention as of right, even if all three requirements are satisfied, the district court has discretion to deny permissive intervention. Practical and equitable or fairness considerations play a large role in the court's decision to grant or deny permissive intervention. In exercising its discretion, a court must consider whether the intervention would prejudice the parties or delay the litigation, or whether the intervener would contribute to the development of the facts and the fair and equitable adjudication of the legal questions. These are important considerations. Quote, the court may also consider other factors in the exercise of discretion, including the nature and extent of the intervener's interest and whether the intervener's interests are adequately represented by other parties. Alphabet and YouTube satisfy the threshold factors for permissive intervention. First, the jurisdictional requirement is inapplicable because this is a federal question case and Alphabet and YouTube do not raise any new claims. And there they quote where if you don't raise any new claims, you don't have to worry about the jurisdictional requirement. Second, the motion to intervene was timely filed just 1 week after plaintiff voluntarily dismissed the corporate defendants from the action. Third, the issue of copyrightability of the live stream is common to this case and to the related case in which Alphabet and YouTube are defendants. Because these factors are satisfied, the decision whether to permit permissive intervention is committed to the broad discretion of the district court. Now, this was always going to be an issue for really anybody, but especially for a pro se plaintiff who has been accused of being a vexatious litigant. The court has discretion. That means the court's decision will not be able to be appealed if you are well within your discretion, unless you can show an abuse of discretion or some kind of clear error. You relied on evidence that was clearly false, something like that. There's no appealing. So if you're doing permissive intervention, you can argue with the court all day, but if the court thinks it's a good idea for the corporate parties to be back in the case, the court will be able to let them in, and you can't do anything about it. Because these factors are satisfied, the decision whether to permit intervention is within the broad discretion of the district court. In exercising its discretion to grant or deny permissive intervention, a court must consider whether the intervention will unduly delay or prejudice the adjudication of the rights of the original parties. The discretionary considerations favor permissive intervention here. Alphabet and YouTube's interests are not represented in this litigation because the individual defendants, the only remaining defendants, have defaulted. Additionally, intervention would not cause undue delay, as there are no pending deadlines, nor will intervention prejudice plaintiff. Plaintiff asserts intervention would be prejudicial because he voluntarily dismissed Alphabet from this action, and permitting intervention would effectively circumvent that dismissal. Let's see what the court has to say. The court finds plaintiff's argument unpersuasive. YouTube was never named as a defendant in this case, okay, so that one's out. And plaintiff cites no authority for the proposition that Rule 41 dismissals prevent permissive intervention under those circumstances. Yes, if you remember, I predicted that the court would look at those as two separate things, and once voluntary dismissal was effective and affected, and even the judge said that the motion to dismiss would be stricken from the record because it was untimely filed 20 minutes after the voluntary dismissal. So that's over. Now a motion to intervene comes along. That's a separate event. And I thought that that's how the judge would see that, and it appears that I'm correct. Moreover, permitting intervention will promote judicial economy and spare the parties from needing to litigate a similar case. The copyrightability of the same live stream is at issue in the related case. Considering the same issue twice in different cases not only wastes judicial resources, it could lead to inconsistent results. So you know what that means. That means that this ruling also eliminates the other case. Even if this doesn't say it, the other case was waiting for this ruling. This ruling says the accidental live stream is not copyrightable. That other case is gone too. Finally, plaintiff's behavior in this case favors permissive intervention. So this is where you can't just game the court and the court goes, oh, I'm just a chessboard and we can't disobey the rules. No, the court has a lot of discretion to handle the case and procedure and move things along to try to get to a fair result. And that's what you're seeing here. Plaintiff has made no secret that he dismissed the corporate defendants to prevent them from challenging the validity of the live stream's copyright, and that he intends to relitigate the same issue in the related case. Plaintiff's abuse of the litigation process and his attempt to evade a ruling on an essential question at the core of both cases favor intervention. For these reasons, the court grants the motion to intervene. YouTube and Alphabet may enter this case as permissive interveners. The court will consider the interveners' arguments in opposition to plaintiff's motion for a default judgment. So the judge doesn't stop here. The judge goes on to the default judgment. Plaintiff has filed a motion for default judgment as to the individual defendants. The interveners opposed plaintiff's motion for default judgment. Federal Rule of Civil Procedure 55b2 permits a court to enter a final judgment in a case following a defendant's default. So default and default judgment are two separate steps of the process. You default by not responding properly, you're untimely, or not at all. You get a default, then the judge at some point comes along and says, okay, here's the judgment on that default. Whether to enter that judgment lies within the court's discretion. And they cite the Eitel v. McCool case. The court identified 7 factors that district courts may consider in exercising their discretion to award a default judgment. 1, the possibility of prejudice to the plaintiff. 2, the merits of the plaintiff's substantive claim. 3, the sufficiency of the complaint. 4, the sum of money at stake in the action. 5, the possibility of a dispute concerning material facts. 6, whether default was due to excusable neglect, and 7, the strong policy underlying the federal rules of civil procedure favoring a decision on the merits as opposed to a decision by technical default. Thank you to Q Squared for your super chat. I'm so happy to see a live stream on YouTube. Thanks for giving us YouTube subscribers something with a little more meat. You're welcome. Here, the sufficiency of the complaint and the merits of the plaintiff's substantive claim preclude default judgment. To state a claim for copyright infringement, plaintiff must establish that he owns a valid copyright in the work at issue. To be copyrightable, the work must be original to the author, which means it must possess at least some minimal degree of creativity. You usually don't see cases where we have to test the minimal degree of creativity, but this live stream, this whole accidental live stream situation, and the bananas case that I just released a video today are both situations where we encounter the minimum degree of creativity required for copyright protection. The work also must be the product of human authorship. Plaintiff cannot establish either element here. So let's highlight these. The work must be the product of human authorship, and of course plaintiff can't establish that. So we have a minimum degree of creativity or originality or authorship and human authorship. Both of those elements have not been satisfied. Thank you to Eric Tams. Happy to catch a live stream. Would you prefer a YouTube membership or Patreon for monthly support? Either or. I'm very happy to have your support, and we'll take it any way you prefer to give it. Plaintiff's arguments in opposition are unconvincing. First, he asserts that the video contains acts of creative individual expression, specifically his facial expressions, which he claims suffice to meet the minimum standard for creativity needed for copyright protection. Not so. Or, fun fact, no. Because plaintiff did not know he was being recorded, his facial expressions were not creative choices. He also argues that accidental works can be copyrightable, but this situation is not like that in plaintiff's cited case where the court found that an unintentional variation in the artist's intended work caused by bad eyesight or defective musculature or a shock caused by a clap of thunder might still constitute creative expression. Here, plaintiff was not engaged in the process of creating an intended work because the recording occurred without his knowledge. Accordingly, the live stream does not possess the creativity necessary for it to be copyrightable. Second, the live stream is not the product of human authorship. Plaintiff himself concedes that his copyright is invalid if the streaming software turned on of its own accord, and that is precisely what he alleges in the complaint. In opposition, plaintiff contends that his allegations should not be taken literally, and that it is likely that the streaming software turned on as a result of an errant keystroke rather than purely autonomous means. Plaintiff's efforts to recast his allegations are unpersuasive. Plaintiff admits he does not know how the streaming software turned on, which means he cannot plausibly allege that the live stream was the product of human authorship. Regardless, even if the court accepts plaintiff's strained figurative reading of his allegations, the lack of creativity in the live stream, as discussed, still dooms his copyright claim. Finally, plaintiff asserts that his copyright is presumed valid because he registered it with the U.S. Copyright Office, which establishes prima facie, on its face, evidence of the validity of the copyright. However, the presumption of the validity of a registered copyright may be overcome by the offer of some evidence or proof to dispute or deny the prima facie case of infringement. I think I called this one too, that this is a rebuttable presumption, and you just have to present evidence. I'm losing my voice here. Here, plaintiff's registration application contained inaccurate and incomplete information. It claimed the live stream was a dramatic work and did not disclose the circumstances by which the recording occurred. Thus, the allegations in the complaint and evidence in the record overcome the presumption of validity of a registered copyright. Plaintiff relies heavily on the earlier screening order, the court's screening order, in which the court permitted plaintiff's copyright claim to proceed. However, as the interveners note, at the time the court screened the complaint, it was not aware that plaintiff's registration was based on an inaccurate application. Additionally, because plaintiff is proceeding in forma pauperis, the court does retain the power to dismiss the case at any time if it deems the action to be frivolous, malicious, or fails to state a claim on which relief may be granted. That's 28 U.S.C. 1915 E2 and is often used by courts to deal with vexatious litigants. Thus, the court's earlier screening order does not preclude it from determining at this stage that the complaint fails to state a claim on which relief may be granted. For these reasons, plaintiff's complaint fails to adequately plead a copyright claim. Default judgment is improper and plaintiff's claims are dismissed. Plaintiff requests leave to amend to correct the deficiencies in his claim. A plaintiff should be permitted leave to amend, unless amendment would be futile. To determine whether amendment would be futile, courts examine whether the complaint can be amended to cure the defect requiring dismissal without contradicting any of the allegations of the original complaint. The court finds amendment here would be futile. Plaintiff's allegations and admissions regarding the circumstances surrounding the creation of the live stream are fatal to his copyright claim. There are no facts plaintiff could allege to save his deficient claim that would not impermissibly contradict his original pleadings. For this reason, amendment is futile. Plaintiff clearly feels aggrieved by comments made about him online by the individual defendants and others, but that does not mean that plaintiff has a viable copyright claim. He does not, and his pursuit of his claim has caused the court to expend significant resources addressing his meritless claims. Plaintiff is warned that if he persists in filing frivolous or meritless lawsuits, the court may impose sanctions, bar him from filing further actions without prior approval, and/or deem him a vexatious litigant. For the foregoing reasons, the court grants the motion to intervene, denies the motion for a default judgment, and dismisses the case with prejudice, and that is Judge Jeffrey S. White, United States District Judge for the Northern District of California. That's exactly what should have happened in this case, frankly, a long time ago, but I guess this is what happens when you poke the beehive or you poke the bear. Like, if Mr. Stebbins had done this a different way, it may have gone further in his favor before finally getting dismissed. I really never see an outcome where an accidental live stream should ever be the subject of a copyright claim. But there are those situations where you're pointing your phone at something and then something happens in the background and that becomes the source of a viral video and it's very valuable and you get paid for it because you own a copyright on it. So let's maybe draw the line that when your computer accidentally live streams something under the circumstances that David Stebbins / Acerthorn says that that's not copyrightable, but maybe if you're recording something intentionally and you hit the button, so you're the author, and you see and something happens in the background that you didn't create, that should be where the line is. That one should be protectable and the other should not. Fluffy Blanket, thank you for the 50 Norwegian kroner. Do you have a chance to look into the copyright case against Mariah Carey for All I Want for Christmas? I'm interested in hearing your take on it. I've not looked into that one yet, but I'll put it on the list. Thank you very much for your super chat. Leonard is in a new house. This is my old house, or rather this is the bedroom I grew up in. Lawful Massimo French was uncivil law copyright strike against the law, knowing it was a false strike. I don't remember what the story was there. Sorry. Somebody would have to remind me. Catching a lightning strike could be an example. Sure. Yes. However, I guess it depends on a lot of the settings on your camera, whether or not your camera would catch a lightning strike. So that I think clearly is on the creative side and protected. Anyway, so that's great. That's the dismissal of the primary case. That should also mean the dismissal of the secondary case. And I'm assuming the appeal will be denied as moot and just denied as moot and it will just go away. Whether Mr. Stebbins can try anything else from here, I don't think so. I think he's already on notice that if he tries anything with the district court, he's going to be labeled a vexatious litigant, or risks that at least. And if he tries anything with the appeals court, I don't know, that would get back to the district court, and you certainly don't want the appeals court labeling you a vexatious litigant either. But yeah, I think that's the end of Mr. Stebbins' case. So I hope we all learned something here. An accidental live stream, just like an AI-generated copyright, just like the monkey selfie, all these things don't have a human author. The accidental live stream also lacked creativity and therefore was not under the jurisdiction of copyright protection. Anyway, thanks for watching. I'm Leonard French, your favorite copyright attorney, and this is a community-supported channel, and I need your money because I don't take corporate sponsors. I get lots and lots and lots of emails from NordVPN and others who want to collaborate in some way or get a sponsorship in some way, and I don't take those things. I don't do that. So I ask the community to support me. So if you would like to support, please support via patreon.com/ljfrench, sponsors.com/law, Twitch subscriptions, YouTube subscriptions, Floatplane subscriptions, and YouTube memberships. So love you all. Thank you very much to my supporters in July. $50 plus supporters are John Steele, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, ShadowTycho, Gutbrodj, PureMagma, Eric Tams, TechTechPotato, The Blood-Soaked Survivors, Wyatt, Calandro, and King Aries. I love you all. I will see you in the videos. Have a good one.